A man spent 22 years in prison because an expert said his teeth matched a bite mark. The science was completely fake. And for decades, American courts let this happen in case after case after case. Before 1993, getting your so-called science into an American courtroom was shockingly easy. The standard came from a 1923 case called Fry versus United States. All an expert needed to prove was that their technique was generally accepted in their field. Here is the problem. What if the entire field was built on assumptions nobody ever tested? Bite mark analysts accepted bite mark analysis. Hair examiners accepted hair examination. It was a closed loop of validation with no outside scrutiny. Prosecutors loved it. Defense attorneys rarely challenged it. And juries treated these experts like they were delivering absolute truth. But the cracks were starting to show. Innocent people were going to prison. And one pharmaceutical company lawsuit was about to change everything. The case that broke the system had nothing to do with crime. Daubert versus Merrill Dow Pharmaceuticals was a civil lawsuit. Parents claimed a morning sickness drug caused birth defects in their children. They brought expert witnesses who used novel scientific methods to prove causation. The pharmaceutical company fought back, arguing these methods were not generally accepted. Lower courts sided with the company under the old Fry standard. But the parents appealed to the Supreme Court. And here is where it gets interesting. The justices realized they were not just deciding one drug case. They were being asked to define what science actually means in a court of law. Think about that for a second. 9 justices with law degrees were about to establish the rules for scientific truth in America. The implications would reach far beyond pharmaceuticals. In 1993, Justice Harry Blackmun delivered the opinion that rewrote the rules. But here is where it gets strange. The new Daubert Standard did not make things stricter in the way you might expect. It actually replaced general acceptance with something more flexible. Now judges became gatekeepers. They had to evaluate scientific evidence using 4 specific factors. First, can the theory or technique be tested? Second, has it been subjected to peer review and publication? Third, what is the known error rate? And fourth, is it generally accepted in the relevant scientific community? Notice that last one. General acceptance did not disappear. It became just one factor among 4. The court was essentially saying that real science can prove itself. It does not hide behind professional consensus. It invites scrutiny. But this raised an immediate question that nobody anticipated. If judges are now scientific gatekeepers, who teaches them the science? Most judges went to law school, not medical school or chemistry programs. They are trained to weigh testimony and interpret statutes. Now they were expected to evaluate falsifiability and error rates. And this is where you need to pay attention. The Daubert decision created a massive education gap. Some judges embraced it. They attended scientific seminars and consulted neutral experts. Others struggled, letting in questionable evidence because they did not understand how to apply the test. Defense attorneys suddenly had a powerful new tool. They could file Daubert motions challenging prosecution experts before trial even began. But prosecutors adapted too. They started coaching their experts to use the magic words, to testify in ways that checked the Daubert boxes. The battlefield had shifted, but the war was far from over. But here is what the Daubert decision could not fix. All those convictions that came before. What happened to the people already in prison based on junk science? And this is where the story takes its darkest turn. Keith Allen Harward spent 33 years in a Virginia prison. An expert testified that his teeth matched bite marks on a victim with absolute certainty. DNA evidence eventually proved he was innocent. But here is the devastating part. The bite mark analyst was never held accountable. He kept testifying in other cases for years. Across America, Innocence projects began systematically reviewing convictions based on discredited forensic techniques. They found pattern after pattern. microscopic hair analysis that FBI experts later admitted was fundamentally flawed. Arson investigation methods based on folklore rather than chemistry. Each exoneration represented decades stolen from an innocent person. And thousands more remained behind bars. So what forensic science actually survives Daubert scrutiny today? DNA analysis passes. It has known error rates, peer-reviewed methodology, and can be independently tested. Fingerprint analysis mostly survives, though its error rates are higher than the public realizes. But what nobody expected was this. Some techniques still used in courtrooms today would fail a rigorous Daubert challenge. Bloodstain pattern analysis. Footwear impression comparison. Even some ballistics matching techniques. These methods remain in use because challenging them is expensive and most defendants cannot afford expert witnesses to rebut them. Think about what that means. We now have a legal standard that can distinguish real science from speculation. But whether it gets applied depends largely on who can pay for the fight. The Daubert revolution changed the rules. It did not guarantee justice. And this brings us to the heart of what Daubert actually accomplished. It gave the legal system a framework to ask a question it had been avoiding for 70 years. Is this actually science, or just confidence dressed up in a lab coat? The answer matters because jury psychology has not changed. When someone with credentials takes the stand and speaks with authority, jurors still believe them. What Daubert did was create a checkpoint before that expert ever reaches the jury. A moment where someone asks for proof. The standard is not perfect. It does not catch everything. It depends on judges who may not understand science and defense attorneys who may not have resources. But it established a principle that changed American courts forever. The burden of proof now falls on the science itself. And that simple shift has prevented countless wrongful convictions. I want you to remember this part. 30 years after Daubert, the fight continues. State courts vary widely in how they apply scientific standards. Some still use the old Frye test. Others have adopted Daubert but interpret it loosely. And new forensic techniques emerge constantly, each claiming scientific validity. The lesson is uncomfortable but important. Justice depends not just on evidence, but on whether that evidence is actually what it claims to be. For decades, American courts assumed that experts knew what they were talking about. Daubert forced a reckoning with that assumption. Today, when you hear about forensic evidence in a trial, you know to ask questions. Can it be tested? What is the error rate? Has it been reviewed by independent scientists? These questions exist because 9 justices realized that truth requires more than a confident witness. It requires proof. Now you understand how one Supreme Court decision exposed decades of junk science in American courtrooms. The Daubert Standard is not perfect, but it gave us something we never